Here we are. Welcome to It's Time to Get Your You Know What Together. And we are here and we will discuss with you everything from estate planning to how to avoid probate administration and everything in between. All right, so let me introduce Samantha Fitzgerald. Samantha is an attorney in plantation, and her firm is 100% focused on estate planning and probate and trust administration. She's been practicing for over 20 years, hard to believe, and she's a CPA and has her LLM in tax. Welcome, Samantha.
Thank you, Bianca. Welcome, everybody. Hope everyone's doing well. Thanks for joining us.
And my name is Bianca Moreras, and I will be your host and moderator. I am a business development and career transition consultant and coach. I bring 37 years of experience to the table with my concentration is in law firms and working with attorneys with the ability to help them and their company move on to the next level.
So today we're going to talk about IRA, other retirement benefits, and what to do with them when you pass away. That's the nature of our topic today. If you've been here on other months, you'll know that we talk about a different estate planning, estate or probate topic each month. So the question was, they did away with the stretch rules. What does that mean? So that is true. So what the stretch rules were, most people probably don't even know what that term means. So basically your retirement accounts, when you put money into your retirement account, you're typically doing that on a pre-tax basis. So you don't pay income tax on it when you put the money in. So when it comes out, somebody's going to pay tax on it, whether you're receiving it yourself from the IRA or whether your beneficiaries or heirs are receiving the money. It's usually subject to income tax, sometimes estate tax as well, but we're talking about income tax now. So until somewhat recently, you were able to leave your IRA to your beneficiary, and they could choose how they wanted to receive the money. They could take a lump sum, in which case they would get paid tax on it right away. They could take it out over a 5-year period, and then they pay tax as it comes out. So they could literally wait 5 years and then take the money out at the end of the 5 years. Or they could stretch it out over their life expectancy. So if they didn't need the money, that was, of course, typically the best choice to make, to leave it in there as long as possible, let it grow, and take annual distributions, similar to when a person takes their own required minimum distributions. They would take their required minimum distributions based on their life expectancy. So if your beneficiary was 50 when you died, their life expectancy per the IRS tables is, probably somewhere around 83, give or take. So they could really stretch out that IRA for 33 years, potentially. So they did away with those rules about a year or two ago, and inserted new rules. So your spouse can still stretch it out over their life expectancy, and certain beneficiaries, such as somebody who is disabled, they can stretch it out over their life expectancy, but there's lots of rules associated with that as well. Most other beneficiaries have to take it out over a 10-year period. So it's similar to that 5-year period where you could just leave it in there the entire time, but at the end of that 10-year period, you have to take it all out. It really ends up being a little bit more than 10 years because it's really by December 31st of the year after death. So it could be, significantly longer than the 10 years, but, that's the rule that we talk about. So okay. You can stretch it, it's just not as stretchy.
Okay. So I've been told that we can't put the IRA into a trust. Is that true?
Yes and no. So you cannot retitle your IRA into your trust. It must stay in your individual name, but you absolutely can name your trust as beneficiary on the IRA. And I encounter this misconception a lot. It's somewhat of a complex topic, although not really as complex as it used to be before they did modify the stretch rules. You absolutely can name your trust as beneficiary. It's easier now since they've modified the stretch rules. And there's lots of reasons, why you might want to do that as well. But yes, you absolutely can name your trust as beneficiary. So if anybody tells you otherwise, tell them they're wrong.
Well, Samantha, dovetailing on that question, if you name the trust as beneficiary, how does that actually work when someone dies?
Okay, so this is where it gets a little bit more complicated, but so keeping a simple answer, you die, you have this IRA account, you name your trust as beneficiary. So it's going to go into your trust. Let's say you have 2 children and they're the beneficiaries of your trust. That IRA will be split up into 2 pieces, 2 accounts within your trust. So it's just like a regular bank account that's in your trust, or the trust for your beneficiaries, for your children. And the distributions out of the IRA should be made into the trust. And then depending on what your trust says, then the distribution may go from your trust to the beneficiary. The trust can be set up in a number of ways. It really depends on what your estate planning goals and objectives are for your beneficiaries. So there's something called an accumulation trust, and there's something called a conduit trust. Conduit means it just goes in and out and directly to the beneficiary. The accumulation trust is where the income, so the distribution from the IRA, it's 100% income because it's all taxable. So that income comes into the trust, and you may accumulate it for a number of reasons. Maybe you have a minor beneficiary. Maybe you have a disabled beneficiary. Maybe you have somebody with drug issues, spending issues, creditor issues, things like that. So the income may stay inside the trust forever or a period of time, or it may be distributed out. But it's kind of like a 2 or 3 steps. It goes from IRA into the trust, and from the trust, maybe it stays, maybe it goes out to the beneficiary.
Okay, I'm glad you're doing this work for us. It sounds a little complicated. Well, okay, so if you have a married person and 2 minor children, who should we name as the IRA beneficiary?
So the favorite lawyer answer is it depends. Oftentimes you want to name your spouse as beneficiary of your retirement accounts because they can stretch it out. Not only can they stretch it out, they can actually put it into their own IRA account. And they don't even have to touch it at all until they're 59 and a half. So it's usually beneficial to name your spouse as the primary beneficiary in your IRA. Not always, though. There could be lots of reasons why you don't want your spouse to get the money. Maybe you're concerned, about their spending habits, or that, somebody will come and influence them. They'll get remarried. You might want to protect your children either from that marriage or even from, a prior marriage or relationship. So typically the answer is going to be, yeah, name your spouse. That's best, but not always.
Okay, that's fair enough. What about in the instance when you have adult children only? Is it okay to name them as beneficiaries of the IRA?
It depends. Again, my favorite answer. Most of the time, I'm going to say, no, we don't want to do that because we want to build in some protections for them. So running it through the trust provides protection in the event they have creditors, if they're disabled, if they're incapacitated, or if they themselves die, before you, or maybe shortly thereafter from you. In Florida, an inherited IRA is protected from the beneficiary's creditors. That's not the case in all states. So if we are strictly looking at Florida and we say, yeah, leave it to your kids because it's protected from their creditors anyway. So you don't need it in your trust. Well, what if your kid lives in Alabama or wherever? I don't know what the creditor protection rules are of all those different states. You never know. Even if your kid lives here now, you don't know where they're going to be living at the time of your death. If the state doesn't have similar rules to Florida, then that money may be at risk to their creditors, even if it stays intact in the IRA. But also looking at those other issues, let's say, you name your adult child as beneficiary and they have 2 minor kids and your child predeceases you. So where does their share go? Well, we don't know. We have to first look to the beneficiary designation form. Sometimes it will go down the line to the grandkids. Well, that's a problem because they're minors. Sometimes it will go to your other living children. Well, that could be a problem because now your grandkids just got disinherited. So naming your trust as beneficiary instead of your kids directly, even if they're adults, is oftentimes beneficial because it gives you lots of protections and lots of flexibility.
Wow, that it's not really complicated, but it feels complicated. I'm like, again, I'm glad you're doing this and not me. And thank you for being so brilliant on this. Is there any way to avoid or reduce income tax on the IRA?
So one option, if you are charitably inclined, would be to leave your IRA to your designated charity as a beneficiary. So, depending on what your estate looks like, if you have the option to, leave your IRA to the beneficiary or a portion of the IRA to the charity, that's a great option, because they don't pay income tax on it. So if you were going to leave something to charity anyway, definitely look to your IRA to do that as opposed to some other asset. I think it's very common for people to automatically leave their IRA to their family, their spouse, their children. But you really have to work with your financial advisor and like Charles, and look to the most advantageous way of disposing of your assets based upon your overall goals. And sometimes, even if you weren't charitably inclined, maybe you become charitably inclined when you realize how much tax they're going to end up paying, on the receipt of the IRA. Maybe there's enough money to, for you to feel comfortable leaving to your kids elsewhere, and then you can leave the IRA to charity. There's other options, you really should talk to your financial advisor about, as far as, maybe looking at your pool of beneficiaries. Maybe you have one child that's a wealthy doctor, so they're in the highest tax bracket. And then you have a child that is a social worker. You can still leave them the same amount of money overall, but maybe leave the social worker the IRA because they're in a lower tax bracket than the wealthy doctor. You might want to consider converting your traditional IRA to a Roth IRA, depending on the nature of your estate. Sometimes it's better, especially if you have a taxable estate where you're paying estate tax on top of income tax, you may want to bite the bullet and pay that income tax while you're alive. It not only, pays a tax maybe at a lower rate than your kids are in if they're wealthy already, but it reduces your estate because you're paying the income tax on it. So that ultimately reduces your overall estate tax. So there's lots of different planning techniques that should be looked at, especially if you have a lot of money in retirement accounts. And sometimes this is really the bulk of somebody's estate. They've worked for a long time and they've just socked away money into their IRA. And now they're stuck with this, gigantic income tax issue. So it's definitely something to discuss with both your attorney and your financial advisor. And something to think about is, as you are working and building your wealth, maybe don't sock so much money away in your IRA. I mean, I know it's good now because you're getting that tax deduction, but you got to look forward a little bit. If you have children that you kind of know what financial position they may be in, maybe you don't want to put away a bunch of money into a deferred income tax structure that at the end of the day, you're going to end up paying, your family unit pays a lot more in income tax than you would had you, invested it in a different way. Perhaps. I'm not a financial advisor, but that's something to at least think about.
Oh, well, it seems like there's a lot more to being prepared for working with your IRA and everything else. And I have a question, and I'm going to open it up to the floor now to those that have a question. What if you wait till you're retired to roll over to a Roth if you have a traditional? And is that something that would change your tax bracket, or they're looking at something else?
Well, it's probably a good idea to do that. And if Charles wants to jump in, he's welcome to. But when you're retired, you're probably in a lower tax bracket than when you were working. So, when you roll it over from a traditional to a Roth, you're going to pay the income tax on that portion of the rollover. So if you do it at a time that you're in a lower tax bracket, that's certainly better than, when you were in a higher tax bracket.
Okay, great. So there is a question from the audience, and the question is, can you talk about the difference between the traditional IRA and the Roth IRA for a minute?
In terms of
It
tax,
says, I'm sorry, go ahead.
in in what terms? Like how they're taxed or how you pass
Right, how they're taxed.
So again, I'm not a financial advisor, but in general, when you contribute to a traditional IRA, you get a tax deduction and it grows tax free. And then when it comes out, you pay income tax on all the distributions. A Roth IRA, you don't get a deduction when you contribute to it, but it grows tax free and it all comes out tax free. So we don't have some of these same issues with the Roth. We still have the same issue of who should you leave it to, and you should leave it, to a trust or minor beneficiaries and stuff like that. But when it comes out, you don't have all those income tax issues. So Roth IRAs or 401ks are great the younger you are, because the longer it will grow tax free and then it comes out tax free. So those are great.
Okay, great. I hope that answered your question. Do we have any questions from the audience, either pertaining to how the IRA works in a trust or something along any of the lines of Samantha's expertise?
I will add, that everybody should really look at their beneficiary designations, because it's really common that people have no idea who they've designated on these accounts. And they have no idea what would happen if the person designated predeceases them.
Mm.
So, at a minimum, you should know what your situation is and what happens. And of course, who you have designated, but what would happen if they predeceased you? Because I see that all the time, where a designated beneficiary predeceases the account holder. And sometimes it's going to go to a person that you didn't intend. Other times, there is no alternate beneficiary names, and that's bad, because then the money gets paid to your estate. So now you have a probate administration when you may have not had one before. And now your IRA is subject to your creditor claims, where previously it was exempt from your creditor claims. So the person that owns the account, when they die, if they have a bunch of debts, whether it be medical expenses, credit card expenses, somebody suing them, who knows what, if that IRA passed directly to the beneficiary, it's free and clear of those claims and debts. But if it has to be paid into your estate, your probate administration, because you failed to name an alternate beneficiary, now it's subject to all those claims and debts.
Wow, that seems like a really important point. Samantha, I have another question in the chat. How do you feel about leaving more money to one child than another? Example, my son is a doctor. He doesn't need the money, but my daughter is an artist and she needs it.
It's a tough one that people struggle with a lot. So it's really a personal decision. So the pros and cons, obviously, the one child needs it, although they chose that profession. The other one doesn't need it, but oftentimes the children will feel slighted if they're treated differently. And in my experience, most clients, despite the difference in economics, they still want to treat all the kids the same. And you have to give some thought to what's going to happen when I'm not here. When the glue is gone from these kids, is this going to drive a wedge between them so that they're never going to speak to each other once ever again? Is that worth it? Or I've had situations, it's less common, but I've had situations where they say, I've spoken with them about it. And, usually it's the wealthier child and they're perfectly fine with it. Hopefully it's true, you know? Um, so it really, really depends on the person and the family. And it doesn't have to be, it can be any sort of combination. So it doesn't have to be obviously all or nothing. It could be a little bit more. There's also other things you can do like lifetime gifting so that the other child doesn't even know about it. So on paper, it appears that they're being treated the same, but there's other ways that you can give things to that more needy child. Even at death, you could name them as a beneficiary on an account. So it goes directly to them that maybe, the wealthier child doesn't even know anything about. So there's ways to be a little sneaky about it.
Sounds good. Do we have some more questions? You're happy to speak up if you'd like. I don't have any more questions right at this moment. Anyone? I don't want to. Pam, you got to come off mute.
Thanks. What happens if you have an IRA, two beneficiaries, one is paid, the other one you're unable to locate? What happens to their money, I guess?
So that's really the bank's problem, because the way a direct beneficiary works is that your executor, meaning your trustee or your personal representative, have no responsibility over those assets. They are paid directly to the beneficiary. It's the beneficiary's responsibility to go and collect, their share of whatever account it is. So eventually, when an account sits there, whether it's an IRA, a regular bank account, whatever it is, when it sits there long enough, the bank will send the money to Florida's unclaimed funds. So everybody should run their name in Florida's unclaimed funds and see if they have any money out there for them. And then eventually, if the beneficiary ever figures it out, they would collect the money from unclaimed funds. If it's a situation where they were named as a beneficiary, they just get it directly from unclaimed funds. If it was a situation where the account really needed to go to probate and then to the beneficiary, they still have to open a probate and then collect the money from unclaimed funds.
Oh, yes. Go. I always check treasure chest. I find money all the time. Can you believe it? It's crazy. So yeah, that's great advice. Are there any more questions? We're coming close to our time.
That one though, a little extra info on Pam's question. If there is an executor, meaning a trustee or a personal representative, even though they don't have an obligation, they probably should at least make this person aware that they're a beneficiary and that this account is there. Because if it's a distant beneficiary, it's a friend or something like that, they might not even know. I mean, they're not a good friend, I guess, if they don't know the person died, but they certainly might not know that they're a beneficiary, named as a beneficiary. So in the role of personal representative or trustee, it's kind of a practical responsibility, let's say, to maybe send out some information and let somebody know. But that's where your responsibility really ends. And then it's up to the beneficiary to go and send the information in, the paperwork, and collect the account.
Very helpful. Did we answer your question, Pam?
Kinda, yeah. I guess but how do I want to explain the word? Because I don't understand this word. ESCHEWMENT. Eschewment. What does that actually mean when it comes to that?
So really typically what that means is when you don't have any heirs at all, your money escheats to the state of Florida, meaning, it defaults to the state. But that's not what happens when there's a named beneficiary and you just can't find them. The money will be transferred to unclaimed funds where it sits forever, waiting for that person to come collect it.
And what happens if that person is deceased? And there's another beneficiary. If there's two beneficiaries, the second person is deceased, they're unable to locate them because they died or whatever.
Depends. If they died before the account holder, you have to look to the beneficiary designation form to see, does 100% go over to the surviving beneficiary, in which case they just get 100%, or does that deceased beneficiary's share go to their descendants? Sometimes it says that on the form. So you first have to look to the form. If they survived the account holder, even by minutes, they're entitled to that money. And then that money would be payable to their estate.
Is that better? Is that?
No, I really didn't want to hear that, but that's okay.
Oh. Sorry, Pam.
Samantha knows.
Sorry,
I'm
Pam.
reaching for straws, Samantha.
Oh, goodness gracious. Well, as always, we'd like to thank you for coming. And Samantha is more than happy to speak to any of you. Her office is always cordial and ready to have you invited in if you would like to go over your information. That conversation is always courtesy for joining us on these Zoominars. And we want to remind you that we're here every third Friday of the month at noon with a new topic. And we're so happy you were here. And I'd like to say thank you. Sam, any last words?
Thank you, everybody, for coming. Enjoy your weekend. See you next month.